Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will XRP cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. The General Counsel for Ripple, Stuart Alderoty, has said that the blockchain firm would immediately appeal its lawsuit against the SEC if Judge Annalisa Torres decides in favor of the regulator in the summary judgment proceeding. This information was provided by Alderoty in an interview that took place yesterday with Blockworks. According to the General Counsel for Ripple, there are 3 different ways the Ripple v. SEC litigation might turn out. Ripple's outspoken General Counsel believes that Judge Torres may rule in the company's favor when it comes to the summary judgment. Second, he stated that the judge has the ability to determine that there are contested facts, which will be addressed over the course of the trial. Alderoty said in his third point that Judge Torres may decide to issue the Securities and Exchange Commission a summary judgment in their favor. Ripple's General Counsel has said that the Silicon Valley technology firm would not accept a victory for the SEC if this scenario plays out, as they want to promptly challenge the case before the U.S. Courts of Appeal. According to Alderoty, Ripple is prepared to take the issue all the way up to the Supreme Court in the event that the Court of Appeals rules against the blockchain corporation. He bolstered the spirits of members of the XRP community by saying that Ripple would win the lawsuit if it went all the way to the Supreme Court. According to Alderoty, the United States Supreme Court will find in favor of Ripple due to its protection against the establishment of an administrative state. According to Alderoty, I would be very convinced that this is a victory at the Supreme Court, not so much because of crypto problems, but because of the guarding against developing an administrative state. In addition, the General Counsel for Ripple has indicated that the much-anticipated summary judgment might take place before the end of this month. As a result of the regulatory ambiguity, Alderoty recommends that new cryptocurrency ventures do not start in the United States. According to Alderoty, these brand-new cryptocurrency ventures ought to be launched in a territory that has well-defined regulations governing the business. According to him, new cryptocurrency enterprises should travel to a jurisdiction where the regulations are clear, not light touch, but explicit. As a result of this animosity, some crypto firms are weighing their options about their future in the United States. According to a story from the previous month, Ripple exec David Schwartz made a veiled suggestion that the business would depart the United States if it is forced to do so. In a recent interview with Bloomberg, Ripple's CEO, Brad Garlinghouse, lent his support to Schwartz's statement by agreeing with it. According to Garlinghouse, cryptocurrency firms are already departing the United States as a result of the country's failure to get its act together. He went on to say that crypto enterprises based in the United States but operating abroad are not appropriate for the creativity of the nation. Despite both parties in the Ripple and Securities Exchange Commission (SEC) case making final submissions and awaiting summary judgment, the main focus still lingers around the regulator's power in providing oversight in crypto alongside unsealing vital documents. Under the latest update, pro-XRP lawyer John Deaton has questioned a statement by SEC Chair Gary Gensler alleging that any crypto besides Bitcoin, DC, is classified as a security. It is worth noting that the SEC is using Ripple for selling XRP as a security. In a tweet on February 27, Deaton stated that there is no consensus regarding securities classification. He made the remarks in reaction to a comment by MicroStrategy Executive Chairman Michael Saylor, who noted that Gensler's remarks are testimony that consensus is building on the classification of security. Previously, Deaton shared the possible arrangements for both parties to settle even as they await the summary judgment. According to Deaton, Ripple would pay $150 million in a settlement if the regulator agrees that ongoing and future sales of XRP are not classified as security. However, he cautioned that the likelihood of the SEC agreeing to the approach was minimal, considering the agency's increased crackdown on the digital asset space. Deaton pointed out that the presiding judge could clarify XRP's secondary sales in this case. It is worth noting that Ripple General Counsel Stuart Alderoty had earlier insinuated that the SEC has minimal chances of winning the case at the Supreme Court based on historical outcomes. The SEC has lost 4 of its last 5 cases in the Supreme Court, thanks to the few that had the courage and resources to fight back against the SEC's bullying and clinging to stretch legal positions that were not faithful to the law, he said. As previously reported, The case received new rejuvenation after a journalist, Rosalind Layton, filed a motion to gain access to the Hinman speech documents. The speech was issued by the former director of the SEC's Division of Corporation Finance in June 2018 and could offer a clear representation of how the SEC classifies securities. Hinman noted that Ethereum, ETH, and Bitcoin are not securities, and the same approach could be applied to ARX. Elsewhere, defense lawyer James Fallon also revealed a new development in another long-running legal battle where Ripple has been facing a class action since 2018. In the matter filed in California, XRP investors sued the company and its CEO, Brad Garlinghouse, for selling XRP as an unregistered security and are seeking damages for the losses they suffered. They are requesting that the court declare XRP a security. As reported by Feinbold, Deaton had filed a motion to join the matter as an amicus brief. In the latest update, the plaintiffs filed another motion opposing Deaton's prayer to be included in the matter. Stuart Alderodi, Ripple's chief legal officer, has said that Gary Gensler needs to stop making decisions about how cryptocurrencies should be categorized in the future. Today, the lawyer said that it was likely that Gensler would make biased decisions in the future. He did this by bringing up a recent interview in which the head of the U.S. Securities and Exchange Commission said that every crypto asset except Bitcoin was a security. Chair Gensler has said again that all cryptocurrencies except for Bitcoin are unregistered securities. Since he already knows how the case will turn out, he can't vote on any enforcement case that involves that issue, tweeted Stutter. Gensler said in a wide-ranging interview with New York Magazine on February 23 about the cryptocurrency market that all other cryptocurrencies were securities because there's a group in the middle and the public is expecting profits based on that group, which he said was not the case with Bitcoin. So his words were taken to mean that all crypto assets except for Bitcoin fell under the SEC's jurisdiction, which got a lot of backlash from the crypto community. Jake Chervinsky, a lawyer and policy lead at the Blockchain Association, said in a tweet that Gensler may have already decided that every digital asset other than Bitcoin is a security, and that until the SEC proves its case in court, it doesn't have the right to regulate all cryptocurrencies. The lawyer also said that Gensler's opinion is not the law. Even though the commissioner said he was in charge of the cryptocurrency business, the lawsuit against Ripple, which has been going on for years, is getting closer to a conclusion. But the community is still waiting for the court to decide whether or not Sharp is a security. Even though we don't know what will happen with the case as a whole, we can look at what has happened in similar cases to get an idea of what could happen. In March 2021, the SEC sued Elbri, a blockchain-based sharing platform, for selling its LBC tokens without first registering them with the agency. But a Court of Appeals judge just decided that LBC tokens are only securities when they are sold during the primary sale. Many people think that Ripple is likely to get a good ruling if it can prove to the court, like Albury did, that it never held an icon. If Ripple wins, XRP could be put back on exchanges like Coinbase and Binance. This would make the coin's price go up by a lot.